One of the questions we frequently get from people who are preparing for or contemplating divorce is, will I be forced to share with my spouse an asset that I acquired before the marriage? And most typically that asset asked about is equity that's been accumulated in a house before the marriage, or perhaps a retirement asset. And the short answer is no. The court will deem that is to be what's called separate property and will remain your separate property, not divided with your spouse. As with a lot of the things in the law, there are nuances to that and steps you must take. So there are actually various forms of separate property, the most common one being an asset accumulated prior to the marriage, but there are also things like inheritance, so money you inherit from a parent or other family member is separate property. Money from a personal injury case is separate property. Money that was gifted specifically to you and not to you and your spouse can be separate property. And then the most litigated topic, which is called passive appreciation. An example of passive appreciation is, for instance, money in a brokerage account, an investment account. And with the passage of time, and as the stock market increases in value, your money increases in value. That happened passively as opposed to as a result of your active efforts. And so the passive appreciation on that separate property remains your separate property, again, not divided with your spouse. The key to separate property from the court's perspective is what's called tracing. The court starts in a divorce with the idea that all of the property at the time of divorce is marital property. The burden is upon the person who has the separate property to demonstrate to the court that it's separate property, and that process is called tracing. So it may be through brokerage account statements, deeds, closing statements from a home, whatever documentation that may be available to you to go back to before the marriage, if that's the basis for your separate property claim, and trace it from before the marriage all the way through to its present day existence and demonstrate that those dollars still exist. Now, along the way, those dollars may have commingled with some marital assets. That on its own does not destroy its separate property nature, again, as long as you can trace it. In some instances, that's something you can do with your attorney or on your own if it's simple. At other times, as you can imagine, that may get complicated by deposits of marital funds, active appreciation, things of that nature, and you may want to involve someone like a CPA to help you in that tracing process. As opposed to passive appreciation is active appreciation, and one of the most common forms of that is someone may make improvements to a home. And they may argue, well, wait, during the marriage we expended funds, we did things to that house, and it was our efforts during the marriage that it increased its value. And so it's up to the parties to show that that did or did not happen. So again, if you have property that is separate property, as long as you're able to demonstrate that to the court, trace it through the process, you should be able to retain that as your separate property and not divide it with your spouse. In the absence of that, it's going to be deemed marital property, and it will be divided by the court, usually in an equal way.